Chapter 11, Real Estate Contracts. In this chapter, we're going to learn about general contract law as well as real estate law. So we got to follow both. In this chapter, we're going to describe the essential elements that make any contract valid, including the effects of the statute of frauds and what that is. We're going to identify different types of contracts and issues that affect validity of contracts, and we're going to learn what those terms mean. We're going to explain various contracts used in the real estate business as well, and the kinds that the real estate agents can prepare and the kinds they cannot. So, what is a contract? It's a good place to start. It's a voluntary agreement between legally competent parties to perform or refrain from performing some legal acts. And for any contract to be valid, it has to be supported by some form of something of value, which they refer to as legal consideration, in order for it to be valid. There has to be something given in exchange by both of the parties of value in order for any contract to be able to be legally upheld in a court of law. Both parties have to be giving something up of value. All right. So you guys got this highlighted? That little note down there? Consideration is actually compensation, the compensation that is given or earned. All right. There are four essential elements for any contract to be valid. They are competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. Okay. You need to know that. There could be a question just on that. What are the four essential elements of a valid contract? You need to know that. In the book, we could highlight and then write the number 4 in front of the title. What are the four essential elements of a valid contract? And then highlight competent parties, offer and acceptance, consideration, and there's 3 types of consideration: legal tender, exchange of value, and love and affection. And then legality of the object or purpose of the contract. And while you're at it, highlight the sentence here about the parole evidence rule.
Got it.
So the essential elements of a valid contract vary somewhat from state to state, and certain elements are uniformly required. However, competent parties, in order to enter, what is a competent party? Well, in order to enter into a legally binding contract, you got to be of legal age and sound mind. You can't be drunk or high at the time. You're not a competent party if you're underage, drunk, or high, or not of sound mind. You can't enter into a legally binding contract that's enforceable in a court of law against somebody who's not, right? Now, New Jersey permits a married minor who's at least 17 years of age to contract for the purchase of real property. According to revised statute 37-2-30, which states minor spouses have the authority to join adult spouses in transfer of realty. So persons under 18 may enter into a valid contract. It's not wise to, because you can't enforce a contract against a minor. They're not considered a legally competent party. And the minor can enforce the contract against you if you're an adult, because you are a competent party. So it doesn't work both ways. If you enter into a contract with a minor, you could enforce the contract against the adult, but you cannot enforce the contract against the minor. So it's not advised to enter into contracts with minors. Um, so the contract is voidable by the minor until a reasonable time after they reach the age of 18. Now, I know it says New Jersey uh, minors who are married uh, are considered competent parties and can enter into legally binding contracts. That is not. You guys both here still?
Yeah.
Oh, I heard it drop out over there for a second. So that is not actual factual anymore. Back during uh, the beginning of Trump's first presidency, you guys may not be familiar with it. A lot of people are not, because the media was not reporting anything positive that he did. But he was actually on a big charge for against human trafficking, especially of sex trafficking of minors. And he did a big role. He actually had a lot of websites. You may have noticed a lot of websites out there removed like the classified ads. They've removed like sections about dating and massage parlors and services and all kinds of stuff like that. Were completely removed from their pages, because those were just covers for child trafficking, sex trafficking. Um, so he played a big role in that. And so, because they saw there was a president that was supporting uh, this kind of charge, special interest groups in New Jersey that were looking out for the safety of minors and the exploitation of minors um, tried to pass laws in New Jersey, and they successfully got them passed then. Can they do it now? Doubt it, especially since they keep pushing like the sexualization of children in schools. And we got a governor that just got elected in New Jersey who's saying that she's going to make mandatory classes for gender identity and expression and transgender stuff for children. That's sexualizing children. Okay, so uh, could it be passed today? Probably not. But good thing it's already now passed into law. They were able to successfully pass this. In the past, a minor could get married with parental consent in New Jersey. Now they cannot. So, despite what it says here in the book still has the same saying. And that's only because that law is still written on the books in New Jersey, that says that minor spouses have the authority to adjoin adult spouses in the transfer of ownership of real estate. However, you cannot be a minor and get married in New Jersey anymore, because they passed a law. However, our politicians are lazy and they don't like to go in there and clean up the other laws that relate to it. So it is still on the books, and that's why it's in our book. So that's why I now have to clarify these things to you. So the exam is probably going to have what's still written on the books in the law. But you should know that in New Jersey, you cannot be married and a minor anymore. So in practice, this does not apply. On the exam, that's a different story. Because the exam just follows the laws on the books. And there's still a law in the book that says that married minors can transfer property.
So can you
Okay.
fight that?
Can you fight what? A
If you
minor
get if
being
you
able
get
to get married?
no, I'm talking about on the test. If you get it wrong on the test because you're following state law, not what the book law says.
Well, I'm teaching you what's in what the rule is here. So you got to, I mean, you could argue it till you're blue in the face. I've been arguing for them to change it for several years already. I spoke to the real estate commission. I spoke to PSI, and they look at me like I got three heads because they don't understand the law. So it basically goes to legal teams and panels that they have that analyze their questions. And I'm like, yeah, that's when you create it, but you're looking over it again. You still haven't changed it. It's still listed on exams the same way, and it's wrong. You know. So can you argue it? Don't even go there. Don't. Why even enter into that drama? Just listen. Study it this way. This is correct for exams, okay, but not in real life.
Maybe you got a 69, you need that 70, and that was the one point that hey, look, that's it.
Take it again. Pass. Looking, you didn't miss by 1 point.
Oh no, I get it.
You got to get 33 wrong, and that's still passing. You missed by 34 points, right? If you fail. So, all right. So that's what a competent party is. Listen, on the next slide, I give a full explanation of this. I redid this. Offer and acceptance. Well, for any contract, somebody has to make you an offer and somebody needs to accept it. It's also sometimes referred to as a mutual assent, okay, where the parties come to a meeting of the minds on all the terms. So the wording of the contract must express all the agreed upon terms, and they must be clearly understood by the parties involved. Consideration, that's something of value that's given or received from the parties in the exchange. And there are three legal forms of consideration: legal tender, which is cash or a mortgage loan; an exchange of value, that's like bartering. I'll give you my Lamborghini for your house, give you this in exchange for that. Or love and affection. No, they're not talking about prostitution. They're talking about, family members. Maybe you're leaving the house, you're giving the house to your child because you love them and they love you. Okay. Um, so the price or amount must be definitely stated and payable in exchange for the deed or right that is received. In a sales contract, the consideration is the entire purchase price. There's no separate agreements on the side. And then legality of the object or purpose of the contract. To be valid and enforceable, the contract must not involve a purpose that is illegal or against public policy. And a valid contract may be oral or written. Yes, you could have a verbal contract to sell you my bicycle, right? And that's legal and enforceable in a court of law, but not for the sale of real estate. Real estate contracts must be in writing. There's no such thing as a verbal contract, a verbal agreement to sell real estate. It's illegal in New Jersey. It needs to be in writing. However, leases can be verbal agreements that are enforceable, although they're highly advised against. Because how do you prove what was the terms of the lease that you agreed upon with the landlord? Oh, they violated the lease. How can you prove it? Well, we went over all these things. Prove it. Well, we did it verbally. Good luck, with that. So, leases actually can be verbal in New Jersey. It's just highly advised against. However, when we as real estate agents are doing leases, they need to be in writing. Everything that we do must be in writing, according to the real estate commission, if we want to get paid a fee, right? Yep. So what is the parole evidence rule? Well, it states that if you have an argument and one person claims that they have a contract with you and they got it in writing, and another one claims that they got a verbal agreement with you, courts will dismiss the verbal agreement in favor of the one in writing because you have evidence. Thus, the name parole evidence rule. The one who has evidence is the one that they'll rule in favor of.
Yep.
So here on these slides, I just took those same things that we just highlighted and I elaborated a little bit more on them, right? So here I wrote, Competent parties, you got to be at least 18 years of age, legal age in New Jersey. If under 18, a contract is voidable and can be voided by the minor because they are not a competent party. Can you enter into contracts with minors? Sure, but they're not a competent party. Now, for exam purposes and exam purposes only, like I got written here, not in real life because the laws have changed to protect minors. They're no longer allowed to get married, even with parental consent. The law still has a statute that says married minors can sign contracts, even though the new law does not allow them to be married any longer, under any circumstances. And I got a link here that references that in a legal website. So you got to be of sound mind, sane, sober adults with no mental disease or defect. But for exam purposes and exam purposes only, a minor under the age of 18 who is married would be considered an adult, and contracts they enter into would be legally binding against them. Here, I'll show you about that married minor stuff. I'm going to click on it, show you. This is from the findlaw.com website. There you go. Can you see it now? Last reviewed September 14th, 2020. Anyone who is of the age of majority, 18 in most states, and who meet other criteria is free to marry whomever they want. It is sometimes easy to get swept up in the celebration of festivities associated with marriage and forget that marriage is ultimately a legally binding contract. And each state, therefore, imposes legal requirements that must be met in order for marriage to be valid. One such requirement is that both parties are a minimum to be married are of a certain age. So many states have marriage age limits that allow minors to get married in certain circumstances. However, more states are banning child marriages, especially with all influx of immigration, where some cultures and countries it's acceptable to marry a 50-year-old to marry a 6-year-old. It's disgusting. Not that was ever legal here in New Jersey, but still, you were having parents marrying off their 16-year-olds and 17-year-olds, in exchange for money or whatever the hell it is. And in some cultures that's perfectly fine, but that's why we needed to protect children here and change these laws up a bit. So, for instance, prior to 2018, New Jersey couples were permitted to get married as young as 16 with parental consent, while minors younger than 16 were permitted to get married with approval of a court. In June 2018, New Jersey became one of the first states to ban child marriages, and now there's a clear minimum age of 18 without any exception. The main provision of New Jersey's marriage age requirement laws are listed in the chart below. Okay, so basically, New Jersey, there is a marriage age requirement. You must be 18. There's no exceptions to that, even with parental consent. And the section of the law that says that is 37:1-6. The minimum age requirement with parental consent is 18 now, no longer 16. Legal age without parental consent, 18. So it's always 18 now, even with parental consent. There's no exceptions for younger marriages. If you want to see what those age limits are in other states, let's see, do we have them listed here? Marriage license information by state. Oh, you got to go into each state to actually see. All right. I don't want to get into that. I was hoping to see if there was like just a list of the ages. See, like Kentucky, it's like 10. Just kidding. It's a joke. It's a joke. All right.
Kidding, not kidding.
Huh?
Kidding, not kidding.
Yeah, kidding. Yeah, sorry, not sorry. No, yeah, no. Don't want to offend anybody that's born in Kentucky or lives in Kentucky or anything. I love you people too. You're all Americans. You're just special. All right. So offer and acceptance is the next one. Mutual assent is when the parties are in agreement to all the terms in the contract. It's said that they have come to a meeting of the minds when we're aware of and we're in agreement on all the terms, right? We came to a meeting of the minds. So the parties are aware of and in agreement on all the terms, which must be clearly stated and understood by all the parties. For the school exam definition of what a meeting of the minds is, it's when the parties are in agreement on price, down payment, and financing method. How you coming up with the rest of the cashosis? For state exam, it's the wider definition. It's simply when the parties are aware of and in agreement on all the terms. School exam focuses more on the financing aspect of that. Consideration, something of value the parties, something of value the parties give or receive from each other in the exchange. It is the entire purchase price. And there are three legal forms of consideration, which you need to know as well. They are legal tender, that's a money or a mortgage loan. And here I got a little note about that. In New Jersey, a deed cannot be recorded in the public records unless it states the full sale price. Even though sometimes in tax records, you look them up and you can see $1 in there sometimes. If the property was sold, that's not legal. It can't be recorded that way. So how come you see sometimes $1 listed as the sale price? Well, because there may not have been a sale. It could have just been like a refinancing or correction made to the deed, like in the names or something. And then it would be listed as $1. Exchange of something of value, goods or services. I will do this in exchange for that, or I will give you this in exchange for that. It's bartering. And love and affection. That's like a gift to a relative. So you cannot just record $1 as the sales price in the public records. It should be accompanied by a letter that states it is in fact a gift. An affidavit. That's a sworn statement that states that it is in fact a gift. Excuse me for hiccuping there. And then we have legality of the object or purpose of the contract. It must be legal. It may not involve an illegal purpose or substance or object and be legally enforceable in a court of law. Whatever it is you're selling or doing has to be legal. It may not be against the law, public policy in order to be an enforceable contract, right? You can't have an enforceable contract to kill somebody. Why? Because murder is illegal. You can't have an enforceable contract to sell crack, right? Because it's a controlled substance. It's illegal. However, anybody ever see Cops? I'm going to bust out with something stupid just to show you. Okay, maybe you'll get a trip out of this one. You guys ever see this episode?
What's the deal? What's going on?
Well, the lady owes me $20. I gave her a 20 and she didn't give me nothing.
Why does she owe you $20?
$20 bill. I gave her a $20 bill.
For what?
For anything. I don't care. Whatever it's for, but she can give me my money back if she ain't gonna do nothing with it.
Okay, were you planning to buy some drugs
Yes,
or something?
I was.
What kind of drugs were you wanting to buy?
Rock.
Rock.
Yes, I was.
You gave her $20
I
back.
gave her $20. She gave me some plaster.
And now you want your $20 back
Yes, I do.
because she didn't supply you with crack cocaine.
Well, if she shouldn't give me nothing, no plaster or nothing, she should have said no.
What's going on?
She come around here a while ago. There used to be some people live right over there that used to sell.
Yeah.
We were sitting out here on the porch in some chairs. So she said, y'all have anything to buy? I said, no, baby, we don't have nothing to sell. So she left one around the corner.
Mm-hmm.
Then she come back 10 minutes later, holler, give me my money back up. No, you ain't bought nothing from here. Don't disrespect my child. This is my child.
Mm-hmm.
I don't sell crack. I'm a prostitute.
Let's get it right.
Well, you thought it couldn't get any better or worse.
Oh my God.
Oh my God. That was funny.
Don't disrespect my child. I don't sell crack. I'm a prostitute.
I'll pass on that next episode. Saturday night at 8. Oh boy.
Yeah, that was something. I was looking for that episode for the longest time for finding that clip. I found it. I just added it to the slide. That is a trip. But that just goes to show you, the cops like, what do you want me to do? Enforce your drug deal here? It's like, I'm not getting you your money back. Get out of here. What are you doing? Um, okay, so once again, you can see here, competent parties offer an acceptance, consideration, and legality of the object or purpose of the contract. So even if she was paying for prostitution services, that's not legal. So that would not be a legally enforceable contract either, unless you're in one place in this country. Anybody know where that is?
Vegas.
No, it's actually illegal there.
New Orleans.
Nevada, it is in Nevada, but it's only one place in Nevada, Henderson County. That's where they got the bunny ranch.
Oh.
Right? That's the only place where prostitution is legal in the entire United States. And that place is wrought with scandal as well. Despite having some politicians that are currently in office and some that have actually even just won, like the mayor of New York. He's for legalizing prostitution. Yeah, putting it back the way it used to be. 42nd Street full of prostitutes and pornography. Yeah, that was a very safe place back then too. So, general contract law states that a valid contract can be oral or written. But remember, we got the parole evidence rule that states that if you got one person that got a contract in writing and another one that's got a verbal agreement, courts will dismiss the verbal agreement for the one in writing. That's the parole evidence rule because they got evidence. Now, contracts for the sale of real estate always need to be in writing in New Jersey, according to New Jersey law. They got to be in writing. There is no verbal agreements to sell real estate. All right. So, anytime a contract is modified or changed, those changes must be agreed to in writing by both parties unless the contract is void. Or unless otherwise the contract is voided. Okay, so licensees must not make any changes or additions to a contract after both parties have signed it. That would be engaging in the unauthorized practice of law. However, if one party signed a contract and the other didn't yet, and we're doing negotiations, you could always make a change to it, which we'll call an amendment. The word amendment has the word mend in it. That means you're fixing it. You're making a change, right? So an amendment is a change to a contract. And anytime you make an amendment to a contract, first of all, you can't do it if both parties have signed it already. Only if one is signed. You could make a change to the contract, but then you need to go back to have the other party initial next to that change as well. So I would suggest you have all parties that sign the contract also initial next to each and every change that you made. Otherwise, the contract is void. An addendum has the word add. So this is like you're adding a page to the contract. That's an addendum. So anytime something is added to the contract, it must be done before both parties sign it. Otherwise, once again, we're engaging in the unauthorized practice of law without a license. So all that stuff we're highlighting here, and then we're writing here on the side. Licensees must not make changes or additions to the contract after both parties signed it. This is practicing law without a license. If only one party signed and there's a change, all parties must initial next to each modification. Okay. Licensees must not make changes or additions to the contract after both parties signed it. This is practicing law without a license. If only one party signed and there's a change, all parties must initial next to each modification. All right. Everybody got these notes and highlights? Okie dokie.
You got it.
So real estate licensees follow both contract law and licensing laws. The REC rules state that to be entitled to a commission, a real estate broker cannot be paid unless they have some sort of authorization in writing by our clients or customer to be entitled to earn a commission. That could be in a brokerage service agreement, a listing agreement, an exclusive buyer's agency agreement, or designated agency, transaction broker, or referral agreement. It is signed by the consumer. And anytime we sign a contract with a consumer, we have to give them a duplicate original of that contract immediately. And this applies to sales or lease contracts, no matter who the broker is working for, on behalf of the seller, buyer, landlord, or the tenant. Statute of frauds usually requires something to be in writing. And for the sales contracts of real estate in New Jersey, they must always be in writing. Always. A lease, however, must be in writing only if it's 3 or more years in length. However, if a real estate licensee is involved, it must always be in writing, no matter the length of the lease term. And leases can be recorded if longer than 2 or more years, so that the parties can record their long-term interest in that real estate. For instance, are you guys familiar with the ShopRite in Edison on Route 1? There's a shopping center that the ShopRite is in. And there's one guy that leased the entire shopping center. And then he subleases it to the ShopRite and to all those other stores that are there. It's like acting like a landlord without actually owning real estate. So he pays rent regardless if the units are vacant or not. And then he marks up when he subleases out those places, he got to mark it up enough to earn enough money for whatever he wants to collect. So he has a really long-term lease with that property owner. So it's in his best interest to record it in the public record that he has that long-term lease in case the owner dies and leaves the property to his kids or something, that they will honor the lease that he has and the agreement that he's allowed to sublet. So this is exam question stuff that's in this box here. You need to know this. Okay, so if a real estate agent's not being used, you could have leases up to 3 years in length that are verbal. However, the law states if it's 3 or more years, the lease has to be in writing. And leases can be recorded if they're 2 or more years. It's extremely risky to rely on verbal contracts for leases. They should always be in writing. Otherwise, how do you know what the terms are? How do you remember what all the terms were agreed upon? And how do you enforce it if you can't prove it? That becomes challenging. And we as real estate licensees, we follow real estate laws, the statutes of the state, 4515, Title 45, Chapter 15, as well as the Administrative Code, which is the rules and regulations of the Real Estate Commission, which is Title 11, Chapter 5. It states that we as real estate licensees must never have verbal contracts. The only time they allow it is for a listing agreement. but we need to follow up with getting it in writing in 5 days. So let's highlight this. New Jersey statute of fraud states that sales contracts for the sale of real estate and any lease for more than 3 years must be in writing and signed in order to be enforceable. And then right there too, that leases longer than 2 years can be recorded.
Got it.
All right.
Got it.
So now we'll move on. Contracts can be express or implied. They could be unilateral or bilateral. They could be executory or executed. And they could be valid, unenforceable, voidable, or void. So now let's learn what all of these terms mean. An express contract, the parties state the terms and show their intentions in words. An implied contract is demonstrated by their acts and conduct. So it's demonstrated by their actions rather than their words. A bilateral contract, bi means two. So a bilateral contract, both parties promise to do something. The litmus test for a bilateral contract is this statement right here. I will do this and you will do that. Okay. Now, everything there has been so far, it's been okay, but here's their definition for a unilateral contract. Unilateral, uni meaning one, on the other hand, is a one-sided agreement whereby one party makes a promise to induce a second party to do something. The second party is not legally obligated to act. However, if the second party does comply, the first party is obligated to keep the promise. Party, party, party. It could be a little confusing if you don't follow the bouncing ball there. And its litmus test, well, they erased it from the book, so I wrote it in here. To determine if it's a unilateral contract or not, you could look at this statement. I will do this if you will do that. Okay. So one example of a unilateral contract is a law enforcement agency offers a monetary reward for someone who aids in the capture of a criminal. Because the law enforcement agency offers the reward, are you required to aid in the capture of the criminal? No. But if you do, they are required to pay you that reward. See, that's a unilateral contract, one where one party has an option to do something and the other party has to, if you exercise that option. You're not required to help them in the capture of the criminal, but if you do, they're obliged to pay you that reward that they offer. So, you guys got those highlights?
Yes, sir.
All right, so then my next slides go over the same stuff. Express contract lays out all the terms, expressing them in words, leaving nothing to interpretation. Those words are usually in writing. And an implied contract is created by one's actions rather than their words. And it's demonstrated by the acts and conduct rather than words. Therefore, it may leave some things to interpretation and cause confusion. Here are some examples of an implied contract. A lease that expires, but the landlord accepts the rent payment for the next month's rent. There was no contract in writing that was signed by the tenant that they're going to sign another year lease. But the actions, the mere actions of the landlord accepting the rental payment creates an implied contract that they're okay with that tenant remaining. At the same token, here's another example. If a bank accepts payments from an owner after the foreclosure process begins, this could be interpreted by the courts that there's some sort of an agreement in place between the lender and the owner for an alternate form of repayment for them to get caught up on the outstanding balance. So the payment would serve as the borrower's evidence for such a claim, and then the judge would dismiss the foreclosure proceeding. This is why lenders will never accept a payment from you after your foreclosure has begun. If you're behind on your mortgage payments, the lenders are going to be calling you. You missed your payment. Can you make a payment today? Can you make any payment today, even a partial payment? They're going to try to collect anything they can. But at some point in time, those calls will stop. And even if you call the bank to make a payment, they're not going to accept any payment other than the full outstanding balance, plus attorney's fees and penalties. Because if they do, it could be interpreted, and you then later show up to the foreclosure hearing in court, which most people don't go to. It could be, it could prove as evidence to the court that there was some kind of agreement in place for you to get caught up on your payments to avoid foreclosure. So therefore, if the owner can show they made payment that the bank accepted after foreclosure began, the judge will kick it out of court. They won't allow the foreclosure because of an implied contract has been created by their actions. Okay, unilateral contract is a contract where one party is required to do something, but only if the other party acts. But they're not required to. They have an option. I guess that's a little bit simpler of a definition than the book where they say party, 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 party. Any contract where one party has an obligation to perform and the other has an option, option agreements must be prepared by attorneys. Otherwise, we're engaging in the unlawful practice of law. We cannot prepare a lease with an option to buy. That can only be prepared by attorneys. Option contracts can only be prepared by attorneys.
And
like here's the
own to rent is like that. Rent to own. Is would be considered that, right?
Yeah, because you could have a lease contract to rent. That's one contract. The rent to own part, the option to buy it, is another contract all on its own. And so that option agreement needs to be prepared by attorneys. Because look, they're usually combined with the lease contract itself. It says, listen, you're going to be renting from me and you're going to pay a higher rent than normal. That excess of the rent is going to get applied towards your down payment if you decide to exercise your option to buy. However, if you do not exercise that option to buy, do you get the money back or does the landlord get to keep it?
They keep it.
It depends what they wrote in the contract.
Mm-hmm.
Do you know what is legal? Is the landlord legally allowed to keep it even?
No.
I don't know. I'm not an attorney. So this is why attorneys need to prepare these things.
Well, I figure because it's the and I guess right when you assume, we talked about this before, right? When we discussed the what they can use for security. So would that technically be considered security?
No, that's different because it was a contract that was a lease with an option to buy. So what is the lease? The lease is the contract between the landlords conveying their property and their rights to a tenant for a limited period of time. In exchange, they pay them rent. So we got the rent amount covered there. But what about the part of the option to buy? Isn't that a contract?
Yeah.
So the landlord's given you the option to buy at a pre-agreed upon purchase price by a pre-agreed upon deadline. What did the tenant give the landlord in exchange for that option? Extra rent. So yeah, the landlord probably would be able to keep it. I do know the answer to this, but I'm not practicing law, so I'm not going to get involved in that, right? Because that would be the unauthorized practice of law. So it gets a little sticky when we start getting those situations. I bet you could go out there and ask a lot of experienced agents, hey, have you ever done a lease with an option to buy? And they say, yeah. You could try clarifying it and saying, so you prepared the contract for that lease with the option to buy? If they say, yeah, they're practicing law without a license. They're either BSing you or they broke the law. All right. So now contracts can be executed or executory. Let's get into these terms. An executed contract is one that's been signed. A fully executed contract can be interpreted in two ways. It could be a contract that's been signed by everyone, it's been fully executed, or it could mean all the terms of the contract have been fulfilled. There's no further obligations that need to be met. Everybody performed and did what they had to do. So the contract has been fully executed. So one involves the signing and the other one is pertaining to the status of the contract. And the executory contract is pertaining to the status as well. Tory means still in progress. So the terms have not been fulfilled. There are things that still need to be done. So when a contract has been executed, it's been signed by one party. If it's fully executed, it's been signed by everybody. And then it's in an executory status until all the terms of the contract have been fulfilled, and now it's been fully executed. You follow?
Yeah.
On exams, you're probably not going to get executory. I never even heard this in my life other than teaching this class. I never even heard an attorney use it. They probably learn these terms in law class 101 too, but never actually use them. But the term executed and fully executed, we absolutely hear them all the time. And it usually pertains to the signing of contracts. So you just need to know it in regards to that. Okay. Okay.
You got it.
Okay, Mr. Hand. All right. So, all right, let's stop right here where we're at right now. We went over a lot of stuff so far, didn't we?
Yeah.
In this short time at the beginning of this chapter. So far, we had learned about contracts being executed or fully executed. I'm just going to recap the terms that we need to know for exams, just showing you how much stuff is in this chapter. We learned that contracts can be executed or fully executed. They can be bilateral or unilateral. They can be express or implied. They can be, we learned about the statute of frauds requiring that all sales contracts be in writing and leases longer than 2 years can be recorded. And let me see, we learned that an amendment is a change to the contract, and all changes must be initial. And an addendum is an addition to a contract, and we cannot make amendments or addendums after both parties have signed it. We learned the 4 essential elements of a valid contract are competent parties, offer acceptance, consideration, and legality of the object or purpose of a contract. And we learned there's 3 legal forms of consideration: legal tender, exchange of value, and love and affection. And we also learned the parole evidence rule states that written contracts take precedence over verbal agreements or promises. and that a contract is a voluntary agreement between legally competent parties to perform or refrain from performing some legal acts in exchange for something of value, some sort of consideration. Okay. And we're not done learning yet. So did you guys get these notes here about the status of a contract executed and executory? We just signed over here. An executed contract can be a signed contract. A fully executed one is one that's signed by all parties.
Got it. Thank you.
You're welcome. Now let's get into validity of contracts. Valid, void, voidable, and unenforceable. A valid contract is one that has meets all the essential elements. And what are the 4 essential elements of a valid contract?
Competent parties, offering acceptance, consideration, and legality of object.
Okay. Or purpose, correct. So a valid contract contains all those essential elements. A void contract is kind of a self-contradictory term because a void contract isn't a contract at all. It's one that's missing one of the essential elements, or one that has already been canceled. So a voidable contract is one that seems on the surface to be valid. However, one of the parties can disaffirm it for some reason. An example of a voidable contract is entering into a contract with a minor. Unless
what?
You tell me.
No, you said a contract entered into with a minor is usually voidable.
Unless that minor was married.
Unless that minor was married.
Yeah.
And the spouse is
thought we
part
said
of the contract, right?
That's gonna be some confusion with the other question too.
I said for exam purposes and exam purposes only, right? We're talking, I'm teaching you for exams right now. You know, but
that's why I was like, wait a minute, we just discussed that it's not legal anymore.
I don't want you to confuse real life and my advice that I give you during these course versus what you need to know for exams, though. Okay. That's the one that's real life. And it's not even my advice, it's real life. It's the law. But for exams, we need to know that a contract with a minor is valid if the minor is married. Then they're considered an adult. Okay. Now, an unenforceable contract also seems on the surface. Okay, let's just get these highlights and let's go to my slide because I got more examples than a contract with a minor is being voidable on my slide. So, you guys got these highlights down?
Yes, sir.
Yeah.
Okay.
Got it.
So here we go. A valid contract meets all the requirements to be enforceable. It contains the 4 essential elements. A voidable contract can be disaffirmed by one of the parties. It may be missing one of the essential elements. Some examples are a contract with a minor, a child not of legal age to be competent, or one party is under the influence of drugs or alcohol. You cannot have a legally enforceable contract against somebody who's bonkers out of their mind because they're high or drunk. One party not of sound mind. They have mental disease or defect of some sort, like Alzheimer's or dementia, or they're just local. Okay. Or they're under the influence of drugs or alcohol. They're not of sound mind. Or undue influence. That means they're being taken advantage of. Don't go to a hospital and get somebody to sign contracts when they're on their deathbed thinking they're going to die tomorrow. And then it just turns out that they got really bad gallstones. They felt like the pain was unbearable, and then they feel like they're dying. I'm dying over here. I'll sign whatever. Just get out of here. Give me the maid medication. Well, they were that's undue influence. You took advantage of them if you get them to sign in that kind of situation, right? Or duress means by force or intimidation. So undue influence is taken advantage of, and duress is by force or intimidation. But these are all examples of voidable contracts. Now, an unenforceable contract, neither party can sue to force performance. However, if they both want to remain in the contract, it would be a valid contract between the parties. That's what they refer to it as. For example, if you've got two buddies, they're out drinking. They're 3 sheets to the wind, so to speak. They're both hammered, and it's hammer time. And you got 2 parties, they're wasted. And one guy's like, you know what? You got a beautiful house. I love owning your house. Really? Because I've been thinking about selling it. Yeah, I'll buy your house. How much you want for it? And they agree upon a price, and they're both drunk. It's all drunken banter, right? And they agree to sell the property, and then they put it in writing, but they're both drunk. If tomorrow, when they both sober up, the seller still wants to sell and the buyer still wants to buy, this contract would be valid between the parties. However, neither one of them can sue to force performance if either one of them breaches the terms of the contract, because they were both incompetent at the time they signed. That's an unenforceable contract. So a voidable contract can be disaffirmed by one of the parties, and an enforceable contract, neither party can sue to force performance. However, if they both want to be in the contract, let them be in the contract. They could carry out the terms if they wish. And a void contract, once again, is a contradictory term because it's not a contract at all. A void contract is either missing one of the essential elements, or it cannot be enforced because it already has been canceled, or is illegal to begin with because it was missing one of those essential elements. Okay. Undue influence means you're being taken advantage of, and you need to use caution when dealing with elderly people. You never know what's going on in people's heads. You don't know if they're not of sound mind or whatever, but, age-related diseases like Alzheimer's and dementia, insanity, bipolar, extreme cases of bipolar. There's plenty of functional bipolar people out there, but there's a lot of extreme cases too where they're not really competent, not functioning either. But there's so many other mental diseases out there too. You can never tell what's going on in someone's head. But I tell you what, Alzheimer's and dementia, we could deal with a lot of elderly people that may have it. But how do you know? They could seem like they're sharp as a tack when they're talking to you. They're just not aware that they're still not living in 1940, right? They think they're in 1940 and they're in 2025, right? So they seem sharp as a tack. They're answering all your questions. They fully understand what's going on. They're fully engaged. There's no way for you to know that they have Alzheimer's or dementia, and you enter into an agreement and you sign a listing agreement with them. So what do you do if you meet with an elderly person, you go over the listing, and they agree to hire you, and they give you the listing? And you put that listing in the MLS, and then a couple of days later, somebody calls you, says, listen, I went to my mom's house and I seen she had all this paperwork from different real estate companies. She said she was interviewing real estate companies and she listed her property for sale with you. And my mom's not selling her property. She's got dementia, and I'm her legal guardian. So what do I do?
You got to pull it.
I do.
Yeah.
Jaren, Kevin, you agree? Crickets.
You have to cancel the listing.
I do?
Yes, you do.
Yeah,
You mean I
because
can't?
the daughter has she has the final say
Guardianship.
for the mom.
Okay. Well, I tell you what, at this point, I just got a call from some stranger telling me that this person is their daughter, that this is their mother, and that
Well,
they're
I mean,
their
yeah, you
legal
need proof.
guardian.
You need proof
Yeah.
of it.
I will ask for ID and prove that she's a legal guardian.
Yeah. And until I get, well, the thing is, it doesn't even matter. That could be her legitimate daughter that called me. But does she have, but is she the legal guardian? Does she really have dementia? Maybe she is the daughter and she doesn't want the mom selling the property because she wants to inherit it when her mom passes and she don't want her selling it. Maybe that's what's going on. I don't
There's
know.
going to be documentation if she has guardianship, so we should have
There
her produce that.
There should be, right?
There
So
is.
so what I would do is I would say, okay, well then here's the address of my office. You can come down to my office and sign bring the paperwork that shows that you're her legal guardian, and I'll have you sign paperwork to cancel the listing. No problem. But I'm going to need that information. I'm going to need some sort of evidence that you're her legal guardian, and then you could sign the cancellation of the listing. But until that happens, I got to still keep marketing and showing your mom's property because I legally have to represent her as my client. And until you show me otherwise. Okay. I actually had that happen. This is an example of something that actually happened. And then the lady was the daughter and was her legal guardian. So she came down, signed the paperwork, and canceled the listing, unfortunately. Nothing they could do about it, you know? So after that, I try to be more careful when dealing with elderly people, but be respectful of them. Don't assume just because they're elderly, their cheese is sliding off their proverbial cracker, you know? So the next time I had an appointment with a guy who wanted to sell his house in Colonia. And nice older guy, beautiful house. I met with him. We were going over signing the paperwork, and I asked him, is there anybody else that needs to sign paperwork with us here today? And he's now this one, he seemed like he may have dementia or something because he's like, his hands were shaky and he's hunting for his words, but that could happen to anybody. It doesn't mean they got dementia, that happen. A lot of older people are shaky, so I was respectful and I asked him, I was just like, is there anybody else that needs to sign contracts with us here today? And he's like, oh, yeah. Thanks for reminding me. My son, he lives right around the corner, though. Let me get him on the phone. He's like, you know how it is. He's like, when they're younger, you take care of them. And when you get old, they start taking care of you. I was like, I understand. And he got on the phone and he called his son, and his son came and they signed the paperwork. They all needed to sign. Which, I mean, it's good because, I mean, you get people with Alzheimer's or dementia, even if you ask them, they may not even know or remember at that given point in time, depending on where they're at mentally, But I said it and it stirred something in him, and he called his son came, signed the paperwork, and we were able to list the property for sale. So I was like, wow, this actually works. So next time I dealt with an elderly person, I did the same thing, treating them with full respect, I got to the point of signing the paperwork and I said, is there anybody else that needs to be signing papers with us here today? And the lady was like, "What are you trying to say?" Like she caught me. She knew what I was getting at. You know, she was really sharp. She was like, "What are you trying to say?" And I was like, "Well, is there anybody else that needs to be signing the contracts with us here today?" She's like, "No, I'm the only owner. Why would there need be anybody else that needs to sign contracts with us here? What are you trying to say?" And I was like, "Well, that's it." You know, and I left it at that. But she caught me. That's exactly what I meant, you know. But she was sharp and she had it all upstairs and she caught, you know. So, uh, but you know, be respectful to people. Don't assume that they're crazy because they're older. Okay. So under duress means force, and undue influence means being taken advantage of. So let's just highlight those things on page 198. All right, now we're going to go over performance of contracts, and that dates in contracts are merely guidelines to follow. We're going to learn the phrase time is of the essence, means it's mucho importante. We're going to learn the ways to discharge a contract. We're going to learn about the terms default and breach of contract, and learn about statutes of limitations and what that even means. So we're going to start off with that one. What is a statute of limitations? It's a time limit in which one has a right to assert their legal rights. There's a 6-year statute of limitations for contracts, foreclosures, mortgages, and cases of fraud. There's a 10-year statute of limitations for lawsuits to recover real property in New Jersey. And remember, brokers are required to keep all records for 6 years, except for expired listings and unaccepted offers, which they must keep for 6 months. You think there's a coincidence there? 6 years for the statute of limitations for contracts and 6 years that we got to keep those contracts? Or is it just a coinkydink? So,
well, what if
what's that? What'd you say? I didn't get you. Hello? Jaren, you there? Okay, guess not. So let's highlight New Jersey generally allows 6 years during which time parties to a contract can seek court action to enforce their rights. And this 6-year period applies to contracts, foreclosures, mortgages, and cases of fraud. And lawsuits to recover real property have a 10-year statute of limitations. Well, there she goes. She'll log out and come back in. Do, be, do, be, do. All right. Well, when she comes back in, she'll ask her question. Let's continue on here. Oh, there she is. What was your question, Jaren? Did you have a question there pertaining to that statute of limitations?
Yeah, sorry about that. I switched my Wi-Fi. I was wondering about the 6-month requirement for like expired listings or contracts that didn't close. What am I missing? For the reason for that timeline.
Just the rules, it's the law.
Oh, okay. I thought there was something
No.
okay, got it.
Okay, but 6-year and the 10-year statute of limitations. And then the rules about record keeping for real estate agents. These are the real estate commission's rules. Okay. You got the highlights here?
Yes, thank you.
So now let's talk about breach of contract and default. It's the same thing. You're in breach of contract or default when someone breaks the contractual agreements to the contract without having a good legal excuse to do so. They can be held liable to the other party. Dates in contracts are merely guidelines, and nobody's considered to be in breach of contract if a date is missed to perform some act that is stated in the contract. Those dates are not deadlines, they're merely guidelines, and courts have well established this. Somebody is not considered in breach of contract simply for not completing something on a date by a date that was stated in the contract. But there are times where we want to make sure that things are done in a timely manner and that those dates do have a strict deadline. If that's the case, we're going to learn about this term called time is of the essence. Of the essence, it's very important. So it is a strict time is of the essence is a strict deadline that must be met. And any party who has not performed on time is guilty of breach of contract if they miss that deadline. Now, use of this term should be strictly left to attorneys to use because it is a double-edged sword. So you got to be careful when using it too, because it can cut both ways like a double-edged sword. So if we're the listing agent, we usually use this term time is of the essence because when a buyer's agent submits an offer for a buyer, they put dates in the contract that they need to produce the mortgage commitment letter by from their lender. And often that date has come and gone, and the buyer's agent never got us that mortgage commitment letter. So pick up a phone and call them. Say, hey, am I missing something? We didn't get the mortgage commitment letter from you. You were supposed to produce it by this date already, and it's late. Is there a problem with getting the mortgage commitment? Oh, no. Let me check. Let me follow up with the mortgage rep. Let me see about getting that for you. Okay. It's like, all right, make sure you get it back to me right away. A couple of days go by, nothing. Call them again. Yo, what's going on with that mortgage commitment letter? Did you what happened with it? They having a problem getting it? Oh, no, he was supposed to send it to me. Let me call him up and see what the holdup is. Never gets back to you. Give him another call. Doesn't answer or doesn't get back to you. Yo, what's going on with this mortgage commitment letter? You can't get any answers on it. Seems like this guy's jerking me around now. Right? Is that the impression you guys would be getting at this point? So I'll call up the seller's attorney and I'll say, listen, I'm having trouble getting the mortgage commitment letter that should have already been produced by the buyer's agent here. They keep saying, oh, the lender's going to get it to him, and then he got a bunch of excuses. Now he's not even answering. I need you to issue a time of the essence order. So the listing attorney will write up a time of the essence order and send it off to the other side and say that by this certain date and time and a deadline that they must produce the mortgage commitment letter by. Otherwise, the contract is automatically going to be killed. Nothing else needs to be said or done if they don't produce it by that date or time. We don't need to send them any other confirmations that we're killing the contract. It's just automatically going to be done if they did not produce it by that date and time. So if they don't get it by then, contract is killed, we can put the property back on the market. So let's say that date comes around now and they didn't produce it. Contract's automatically killed. But then the next day, the agent calls up and says, oh, we got the mortgage commitment letter. Contract's already dead. It's killed. Can we put it back together, though?
Yeah.
Sure. Does the other side have to agree to put it back together exactly the way that it was, though?
Yes, both parties.
No, they don't. Contract's already been killed.
That's a
You're
new
trying.
contract.
It's
Could
you're
somebody do
trying.
that as like a strategy? Like if they want to change something, it's too late.
Yeah, but it cuts both ways, and both parties don't need to agree to it. Remember, you're the one that's breaching contract if you're the buyer's agent, right? The
Yeah,
buyer already breached the contract.
yeah.
So, you're trying to use it as a negotiation strategy. That may not be good. They could be like, well, we're just going to sue you because you broke the contractual terms without having a
Got
good
it.
legal excuse to do so, you But we have mortgage contingency clause that basically says that if you can't get the mortgage loan, then, then that's, the contract could be killed, but we can't go after you for damages for that because, you wanted to get the loan, you just were unable to. But if
Got
you
it.
turn out the next day that you got the letter, but we're willing to put it back together, but only if you change some terms. Well, hold on a second. Are you really acting in good faith now? Or are you playing games? We don't know.
Yeah. And what
You know,
about isn't it, can you not show properties or only wait to show a property once they have a mortgage commitment letter?
uh, the mortgage, usually we don't get mortgage commitment letters like that. Uh, we'll get pre-qualifications and pre-approval.
That's what I meant. A
Pre-approval.
pre-qualification. That's what I meant.
But so pre-qualification is the first step where you just get on the phone with a mortgage rep, tell them your social security number so they could run your credit score, and then you tell them how much money you make and what your approximate long-term debts are. They run the numbers and then they issue you a mortgage pre-qualification letter. Doesn't mean that you even qualify to get the loan. None of that information has been verified other than your credit report. Now, a mortgage pre-approval letter, now they verified all of your pay stubs, tax returns, bank statements, all that stuff. So then they issue a pre-approval letter because now you're definitely going to get the loan as long as the property meets the requirements. Now it appraises for the purchase price. There's no wood destroying insects, things of that nature. So then you find the property and you put it under contract. Then we get an appraisal on the property and a home inspection. And then the lender gets a copy of both of those and it goes through their underwriting. And they then would issue a mortgage commitment letter where the lender is committing now to giving the loan to the buyer for this house, that they're definitely getting the loan. No other contingencies need to be met as long as there's no changes in your employment, So that's what you start off with, the pre-approval letter, then you go to pre-qualification letter, then you graduate to a pre-approval letter, and then we get the mortgage commitment letter, and then finally the loan. So we're at the point they're not giving us that commitment letter. What's going on with underwriting? You having a problem getting the loan? That's where we're at right now. So we're issuing this time of the essence letter. And then if they don't meet that deadline, contracts automatically kill. Can we put it back together? Yes. But the parties don't have to agree to put it back exactly as it was because it was already killed. So be careful in using this term because it couldn't cut both ways. So a strict deadline that must be met in contracts, time of the essence. Another term you need to know. Means the contract must be performed within the time limit specified, and any party who has not performed on time is guilty of breach of contract. You see, they even follow up by saying this powerful phrase is a two-edged sword, and licensees should leave its interpretation to attorneys. When a contract does not specify a date for performance, the acts it requires should be performed within a reasonable time. In most common situations, real estate sales contracts stipulate a target date and place for the closing. If that date comes and goes without settlement, the contract may still be valid. Either party may later make time of the essence. Again, that action should only be taken with attorney's legal advice. All right, now we're going to learn about assignment or assumption, assuming a contract. That's when one party signs the contractual agreements that they have over to someone else to take over that contract. Most of our lease contracts and sales contracts stipulate that the contract cannot be assigned to someone else. In leases, you probably see this more than in sales contracts, where somebody tries to assign a contract or assume a contract. That basically is like subleasing. You know, our contracts always forbid subletting, and most landlords do as well. But it depends on what they wrote in their lease. If they didn't write it in their lease, then it may be allowable. So it's important for landlords to put in their contracts that the tenants that they selected, that they agreed to rent to, cannot sublease to some other tenant. Now, if a landlord does allow it, the original person who was leasing is never relieved of their obligation. So if the tenant that they found to replace them and sublease to does not pay the rent or violates one of the other lease contractual terms, the original tenant that the lease was given to can still be held liable for the violation of the terms of that lease. They always hold the primary responsibility, even if it was subletted to someone else. Someone else assumed their obligations. So the example there is a sublease where a new tenant doesn't pay the rent, so the original tenant is still liable for the rent. They're never relieved of that obligation. So what if you want to be relieved of that obligation? Well, we have something called novation, another term you need to know for exam. Novation is substituting or replacing an existing contract with a new agreement. The original contract does not hold any legal force anymore because it was replaced with a new one. Or instead of replacing the contract, we have something called novation of the parties. It's similar to novation. However, instead of replacing the entire contract, we're just substituting the parties named in the contract. Where the original person has no further liability, they're no longer bound by the contract because they've been legally replaced by another person. That's novation of the parties. I think you'll get just novation on exams, though, usually. And this definition is a lot clearer than what's in the book, so I would suggest taking a screenshot of this. Okay, good. So here's what you get in the book. Assignment refers to the transfer of rights or duties under a contract. Unless a contract specifically forbids it, rights may be assigned to third parties. Novation is a substitution of a new contract for an existing agreement. The new agreement may be between the same parties, or a new party may be substituted for either. This is novation of the parties. In the case of novation, the old contract no longer has any force. That's the explanation they give in the book. Now, your version of this book has an additional sentence there under novation. After this, it says, you should probably highlight it too. It says, in the case of novation, the old contract no longer has any force or effect, thereby relieving all parties of their obligations to the original contract, which has now been terminated. I guess they tried to fix the definition a little bit, but it's still a little jacked up. And let me just make a little note here to replace this slide. Oh, the hell's that? That's interesting. How did I get that? Hmm. Oh, interesting. About 32. So let's go over the different ways to discharge a contract at the bottom of page 199 there. A contract can be completely performed with all its terms carried out, or it may be breached. That means broken if one of the parties defaults. In addition, there's various other methods by which a contract can be discharged, and these include partial performance. When the parties have only partially performed their legal obligations or promises within the contract, they didn't do everything the contract required them to. Or by substantial performance, when the parties performed the terms of the contract, but they didn't substantially perform or do everything exactly the way the contract required them to. Or impossibility of performance, when the terms of the contract cannot be legally accomplished. For example, they're not able to get a permit to use the property for the intended purpose, or they're unable to get the certificate of occupancy due to condition or some other legal condition cannot be met. Or by mutual agreement, both parties just mutually agree to cancel the contract, in which case nobody's in breach. Or by operation of law, like voiding a contract as a result of fraud, a contract with a minor, expiration of a statute of limitations, or contracts being altered without all the parties agreeing to those altered terms. Remember, consent for any changes to a contract are required by all the parties. They need to initial and sign next to them. So, default or breach of contract is once again when somebody violates the terms of the contract without having a good legal excuse to do so. They can be held legally and financially liable to the other party. Now, here is something from, I think it was chapter 4. If you did not highlight it, you probably should have. It's an injunction. When a judge orders someone to do something or refrain from doing something, that's called an injunction. When a judge orders somebody to take action or refrain from taking action of some sort. So right now we're going to go over, if the seller defaults, what can the buyer do? And then we're going to go over, if the buyer defaults, what are the seller's options? So a buyer can rescind the contract. They could cancel it and recover their deposit money, their earnest money deposit or good faith deposit, whatever you like to call it. The buyer can sue the seller for the buyer can sue the seller, forcing them to carry out the terms of the contract as they agreed to in the contract. This is known as specific performance. That's what the lawsuit is called. You're suing the seller to perform as they promised in the contract. So an example of this is the seller backs out of a legally binding contract because they just changed their mind and don't want to sell anymore. That's not a good legal excuse. The buyer can sue the seller to have a judge issue an injunction, forcing them to turn over the ownership as agreed to in the contract. They got all their stuff waiting outside in a U-Haul to move into the house, and now you're here at the closing table just saying, I changed my mind, I don't want to sell. That buyer's got a lot of money in so far. They did home inspections, appraisals, they had title searches and title insurance and homeowners insurance, and they already ended their lease or wherever they were and or sold their house, and they're ready to move in, and now the seller's saying, I don't know. Well, you're in breach of contract. You can sue a seller, forcing them to turn over the ownership at this point. That's called specific performance. Now, let me give you a little tip here. As a general rule, you can force a seller to sell, but you cannot force a buyer to buy unless they're a moron. That's a real thing, actually, unless they're a moron. Now, what do I mean by that? Well, you'll find out once we get to the next one where we talk about what the buyer can force the seller to do, or rather, what the seller can force the buyer to do. So the last thing here is the buyer could also sue the seller for compensatory damages. Compensatory damages. That's moolah, money, compensation. All right, so liquidated damages, before we get into what the seller, what the buyer can do, what the seller can do if the buyer breaches the contract. Let's first go over this term, liquidated damages. Liquidated damages is an agreement made in advance about how much money will serve as compensation if one of the parties, usually the buyer, defaults. So this is on page 219. Liquidated damages are an amount of money agreed to in advance by the buyer and seller that serves as compensation if one of the parties does not live up to the contract. But check out the following sentence. It says if a sales contract specifies that the earnest money deposit serves as liquidated damages in the case of default by the buyer, the seller is entitled to keep the deposit if the buyer refuses to perform for no good reason. However, the seller who does choose to keep the deposit as liquidated damages may not sue for any further damages. See, liquidated damages is just an agreement on how much money will serve as compensation. That's separate from where's that money coming from. So if you're going to claim the money, that's the deposit money, which could be far less than the liquidated damage agreement amount, well, that's all you get. So that's my side note down here as well. It says there could be additional wording stipulating where that money would come from, but if it is stated in the agreement, for example, the damages would be paid from the earnest money deposit, the other party could not collect any additional money other than that. And damages are not necessarily coming from earnest money deposits. Damages could exceed the earnest money deposits collected. So if you get a question on an exam that asks what liquidated damages are, one of the answer options are earnest money, the earnest money deposit. Wrong. Liquidated damages is just an agreement of how much money is to serve as compensation. That's all it is. All right, let's get into this now. If the buyer defaults, what could the seller do? Well, if there was a liquidated damage agreement in the contract, it's not a standard thing in all contracts, despite the book making it sound like it is. The seller can declare the contract forfeited if the contract stated they can, and if it was agreed that they would be awarded compensation from the buyer as liquidated damages. Now, where the money's coming from is a different story altogether. Now, sellers could rescind the contract as if it were never made. However, this would require them returning all the deposit money to the would-be buyer. And remember, I told you about the seller can sue the buyer for specific performance only if they're a moron. What did I mean by that? Well, the seller can sue the buyer for specific performance. However, this would require them to sign over the deed and give it to the buyer and then chase after them for the payment. So in other words, if a seller said, you know what, I want to change my mind, I don't want the buyer changes their mind and says, you know what, I don't want to go through with the purchase. And then the seller is like, yeah, okay. And they sign the deed and give it to the buyer. And the buyer accepts the deed. The transfer of ownership takes place when? Upon delivery and acceptance of the deed itself. So now the buyer took the deed, they took ownership of the property. So now the seller's like, oh, you're now the owner, you got to pay me. Sounds kind of silly, right? But no, if a buyer didn't want the property, what did you think? They were just going to give you the deed? They're just going to give it to you? Now you have to pay them if you accepted it. So you got to be a moron. Don't accept the deed from the seller if you don't want the property. So the seller can sue for compensatory damages, forcing the buyer to pay them as well. That's the fourth option. Okay. Just to give you an idea what happens in contracts, when we have deals that sometimes they fall apart, what can happen? There could be legal consequences to one of the parties, and we should be able to explain to them what could happen if you do this or if you do that. All right, so let's do the highlights now in the book pertaining to all of this stuff. Everybody got all these notes?
Yes, sir.
Yogi. All right, now let's look at preparation of the contracts. We're going to start winding down this chapter by going over uh, all the forms and contract and the documents in the contract. So, New Jersey licensees can only prepare sales and lease contracts for 1 to 4 family and single residential lots. Otherwise, it's considered commercial real estate, right? And we cannot prepare those sales or lease contracts for properties over 4 families or more than one lot. The key here, don't leave blank lines on contracts unless a blank line has a definition and explanation of what it means. Commercial industrial property sales and lease contracts or option agreements have to be prepared by attorneys, and licensees may prepare non-binding term sheets to get the ball rolling with the leases and sales contracts for commercial properties. But we don't actually prepare the contract. Only a lawyer can do that. Contracts must indicate the business relationship that we have with the parties in the contract. The Opinion 26 notice has to be sitting on the contract as the cover page, stating that they have the right to hire a lawyer if they're not using one, right? New Jersey has on the top of the first page of the actual sales contract for sales and lease contracts, it has the wording that this is a legally binding contract at the top of the page. What the phrase actually says is a little more wordy. It says this is a legally binding contract that will become final within the 3 business days. And during that period, you may choose to consult an attorney who can review or cancel the contract. All contracts prepared by licensees must disclose your agency relationships in the document. Here's the top of the contract for sales and lease contracts. It would say this is a legally binding contract, and you see the rest of the phrase. Okay. Just to give you an idea what it would look like. And on the top of page 202, which is the first page of the sales contract, you can see it says that, right? This is a legally binding contract there at the top.
Yep.
All right, this is what attorney review looks like in the contracts. Many states do not have attorney review. Attorneys only get involved if there's a problem in the transaction. This explains Section 35 of the actual sales contracts and lease contracts. Section 35 is the attorney review clause. You got number 1 is a study by the attorneys. Both parties must receive a duplicate original of the fully executed contract. Then we start counting of time to deliver the fully executed contract to both sides' attorneys to start the review, make changes, or cancel the contract. Now, this is not what it actually says here. This is an explanation of the attorney review clause in the contracts. Then we have the counting of time. We count 3 business days. We don't count weekends or legal holidays. Review period can be extended or temporarily halted if both sides agree. To begin attorney review to make modifications or cancel the contract. Otherwise, the contract becomes legally binding as it is. And then nobody can make changes to the contract without the other side's approval. The notice of disapproval, one side's attorney starts the review process, acknowledging receipt of the contract and proposes changes to it. Each side has 3 days to respond to the last side's correspondence. And this goes back and forth until one of the sides agrees to the final terms. And then we call this the meeting of the minds when they do. And they all sign off on it, and attorney review is concluded, and we are now considered to be in a legally binding contract. So what is the meeting of the minds? It's when both parties are in agreement on and aware of and understand all the terms of the contract. They're now in a legally binding contract. All right. We also have the federal lead paint addendum that needs to be given by the parties. It needs to first be filled out by the owner. When the property was built prior to when?
1978. That's almost
1978. You need to know that. And so, what are the three things that we need to give to all buyers or renters for properties built prior to 1978?
What are the three things?
We need to give to all buyers or renters that are buying or renting a property built prior to 1978.
The lead-based disclosure form,
That was first filled out by the owner.
the pamphlet book,
The pamphlet about informing them of the hazards of lead, and
and the right to inspection.
we got to give them a 10-day opportunity to have an inspection for lead or waive that opportunity if they wish to close any sooner. Needs to know. Okay.
Got it.
So, using the contract forms, we're going to need to know about using the contract forms. We use listing agreements. Each MLS has their own. We deal with exclusive buyer brokerage agreements, designated agency agreements, dual agency agreements, and transaction broker agreements. There's no actual name for the sales contract. You could call it a sales contract, a purchase contract, a contract of purchase and sale. It goes by many names. So don't be all high and mighty that whichever one you select and choose and prefer to use, that's the one you got to use. Okay. Look, it goes by, there's no official name for the contract. Some people call it an offer to purchase, a contract of purchase and sale, an earnest money agreement, or binder and deposit receipt, or something else. Okay. There's no official name. You could just call it the contract. Offer and acceptance is one of the essential elements of a valid contract, right?
Yep.
So a broker lists and owns the real estate for sale. A broker lists and owns real estate for sale at a price and conditions that are set by the owner. Even though we give a CMA and we try to suggest a price for them, who ultimately sets the asking price? The owner. Who sets the sale price?
Who sets the sale price?
Yeah, what determines the sale price?
The buyer, whatever they contract to buy it for.
Whatever a buyer's willing to pay. So it's the buying public through the operation of supply and demand, right? So this is offer and acceptance in the book. And this is the offer and acceptance explanation that I have. So let's do these highlights, and then we'll go over to the next slide and actually read it from mine. Make sure you write these little notes I got down here, but not required for offer to be considered accepted down at the bottom
there. The wording is different in my book on 217.
On 217, the wording is different. I'm sure it is, and I need to make a note of that as well. So this is slide number what and what? Offer and acceptance. This is
in my book. It says after counter offer. It says any counter offer immediately terminates any previous offer, relieving the parties of their obligations under that offer and returning everything to the status quo.
And that's on page
217.
217. All right. So you're on page 217, you're still highlighting on the second paragraph, the first sentence, the first line. Any attempt by the seller to change the terms proposed by the buyer creates a counter offer. And then 1, 2, 3, 4 lines down from that, you're going to be highlighting the buyer's relieved of his or her original offer because the seller has in effect rejected it. So it's not the next line, it's actually 4 lines down. Okay.
Can you repeat that again? The line that
Yeah.
was the buy.
So on page 217, this first line is the
Yeah.
first line in the second paragraph on page 217. And then this next line that I have highlighted on screen is 4 lines down from that. It says the buyer is relieved of their original offer because the seller has in effect rejected it. See, they just put a bunch of sentences in between. They put 2 sentences in between. Any counter immediately terminates any previously offer, relieving the parties of their obligation under that offer and returning everything to the status quo ante. That offer, once terminated, can never be returned to. The best the parties could do is create a new counter offer on the same terms as the terminated offer. Yeah, you counter back and forth, counter back and forth. And then there's a graphic image there in the center of the page. And just beneath that, the paragraph there, we're highlighting an offer is not considered accepted until the person making the offer has been notified of the other party's acceptance. And underline notified of the other party's acceptance. And what I would write here is in contract negotiations, delivery, acceptance, and signatures not accepted. So here I wrote delivery, acceptance, and signatures are not required but recommended. Or you could write in contract negotiations, delivery, acceptance, and signatures are not required. It's suggested. And then you're highlighting should be followed up with the original signatures as soon as possible, but not required for offer to be considered accepted. Just let me know when everybody's got that. And I'll move on to the next slide, which explains this in my own wording.
Got it.
Got it.
Okay, so here, you're probably better off just taking a screenshot of this, explaining how this works. You know, one of the essential elements for offer and acceptance to work. What is offer and acceptance? What is offer and acceptance? So it's one of the essential elements of a valid contract. And that's also known as the meeting of the minds, where the parties to the contract are aware of, understand, and are in agreement of all the terms of the contract. And this is done by the process of offer and acceptance. So how does it work in real estate contracts? Well, the seller lists the property for sale at an agreed upon sales price. And we help them come up with that sales price by doing a CMA for them, a comparative market analysis, not an appraisal because we're not licensed appraisers. A buyer then makes an offer at that full listing price or perhaps another amount, which could be less or more. And then their broker presents that offer to the seller's agent within 24, and then within 24 hours, we need to forward that or present it to the seller. The seller then either accepts the offer, rejects it, or they can make a counter offer to the offer that had been made, which is basically a rejection of the buyer's initial offer. So at that point, the buyer doesn't have to do anything. They're free to walk away at that point if that ever happens. Now, if the seller makes a counteroffer, the buyer could then either walk away or they could accept it, reject it, or make another counteroffer back to the seller. Then they go back and forth like this until one of the parties agrees to the last offer that was made. And when they do, it's said that they've come to a meeting of the minds and that the contract offer is accepted pending attorney review. It's still not a legally binding contract until attorney review had been concluded. Or if they don't do attorney review, they both sign the contract, receive the duplicate original, and wait 3 business days, and then the contract is legally binding as it is. Now, in contract negotiations, when is an offer considered accepted? It's when the last person who made the offer has simply notified the other party that they've accepted it. It doesn't need to be in writing, although it's highly advised to get it in writing. Technically, in contract negotiations, when is an offer considered accepted? Simply when the other side's agent has been notified it's been accepted. Because anytime you tell the agent something, the agent's required to report it back as part of their fiduciary duties to their client. So once an agent's been notified it's accepted, the other party, the buyer or the seller, has been notified it's been accepted. And this can be done verbally. However, it's highly suggested and a good practice to always follow up with getting it in writing. Even though technically you're not required to for the offer to be technically accepted. But what are we going to do? Send the verbal offer to the attorneys? So it's always suggested we get it in, follow up with getting it in writing. But for the exam question answer option, in contract negotiations, when is an offer considered accepted? When you've been notified that the other party's accepted. That's it. They give you another answer option, like when you've been notified and they follow up with putting it in writing and delivered it to you signed and in writing. No, it's suggested you do that. You follow up with getting that. But technically, it's just when the other side says, hey, they accepted your offer. Congratulations. It's accepted. Okay. That's the correct answer technically for exams. Simply when you've been notified. Okay. Any question?
No, sir.
Okie doke. So earnest money deposits it's customary but not essential for purchasers to provide a cash deposit or a check when making an offer to purchase real estate. And this cash deposit is commonly referred to as the earnest money or good faith deposit. It gives evidence of the buyer's intention to carry out the terms of the contract. So the deposit's given to the broker, and the sales contract typically provides the broker or seller's attorney holds that deposit money until closing. We'll put it into our escrow account. And if the offer is not accepted, that earnest money would be immediately returned to the would-be buyer. We're not allowed to accept credit cards for the deposits. The amount of the deposit's a matter to be agreed upon by the parties, but generally the deposit should be sufficient enough, large enough, to discourage the buyer from defaulting and to compensate the seller for taking the property off the market and cover any expenses the seller might incur if the buyer does default. A purchase offer with no earnest money is still valid. Most contracts provide that taking the property off the market and covering any expenses the seller might incur if the buyer defaults. A purchase offer with no earnest money, however, is still valid. Some contracts provide that the deposit becomes the seller's property if the buyer defaults as liquidated damages. If you wrote a liquidated damage agreement into the contract, it's not a part of standard contracts. Earnest money must be deposited by a broker within 5 business days in their escrow account, trust account, whatever you want to call it. This money cannot be commingled or mixed with the broker's own personal funds. A broker may not use such funds for personal use either. This is an illegal act known as conversion. Yeah, because if I spend your money, it now became mine. I converted your money to mine. Hey, it's conversion. That's where they get those terms from, I guess. Remember, any cash deposits of $10,000 or more, we got to report it to the IRS. So what are you going to do? Accept cash from people? Can you?
Yeah.
You can. But my advice is,
I'm gonna
should you?
try not to.
No.
No.
Get a bank check.
Yeah, certified check, bank manager's check, because if they give you any counterfeit cash, that's got to be reported, and that's going to become a problem. If they give you $10,000 of cash or more, you got to report it to the IRS. And if you get mugged, you're responsible for that money. So better off getting that certified check or bank manager's check, right? We want to try to even avoid personal checks is my advice. You could accept them, but I advise that you don't, because what if they,
How about wire transfers?
We really want some sort of a check so that we could track it. So we could have some sort of a documentation in our files. Do wire transfers occur? Yeah, but probably should have certified check or bank manager's check. All right. So here's my little story on this, where I elaborated a little bit more with my own story, once again, of the notes that you just highlighted. Earnest money is sometimes called a good faith deposit, and it's the money the buyer puts down when making an offer. It shows the buyer's operating in good faith and plans to complete the transaction. An offer is still valid even if made without any good faith deposit, which is customarily at least $1,000. You should have $1,000 if you're buying a house, right? Property. Would that be a little red flag if you got a buyer that doesn't want to put any money down?
Yep.
Or they only want to put $100 down or $500 down? Look, it's customary to put $1,000 down. Why wouldn't you just put $1,000 down? To me, that signals a problem. Either that buyer's not operating in good faith. Legally, they don't have to put any deposit down, but it's customarily to put down a minimum of $1,000 good faith deposit. And if they're not doing that, I'm like, yo, what's up with this buyer? It's a red flag for me. So the buyer is asking the seller to take their property off the market. So they want to make sure the deposit's large enough to show they're serious with their intentions. And if the seller rejects the offer, the earnest money deposits immediately return to that would-be buyer. If the offer is accepted, the money will be credited towards the buyer's purchase price. And if the buyer breaches the contract, the seller could make a claim to keep it. Both parties would have to agree to that. And if they don't, only a judge could decide who gets the money. And if there was a liquidated damage agreement added to the contract, which specifies the earnest money would serve as damages, well, then they could take it. Brokers must deposit any money given by our clients into an escrow or trust account used only for keeping our clients' money for short periods of time. It must be deposited within 5 business days from the time the client gave their agent the money, not from the time the offer is accepted. And any cash deposit at $10,000 or more has to be reported to the IRS. And the broker is required to keep escrow records for how long?
6 years.
6 years. So if you guys want to take a screenshot of this explanation, which is a little bit more straightforward.
Got it.
Got it.
You know, the only time I would not consider it fishy or a red flag when a buyer does not put down $1,000 good faith deposit is when they're submitting a digital contract, an electronic contract that they put together while they're there at the property. But I would always ask that they put down some sort of a good faith deposit, if not now, by a certain deadline. I want
How
them
would
to
a
have,
digital, sorry, finish the
yeah,
thought.
I want them to have some skin in the game and have some money there. Otherwise, for all I know, they're putting offers in on 10 different properties and seeing which one it gets accepted, and then they'll accept their favorite one. So they're not really operating in good faith. They're not intending to go through with the offers on all those properties. So putting an offer in on all those properties is not exactly operating in good faith. Go ahead. What was your question?
How does a digital offer work on the spot? I've never heard of that.
Oh, well, it's an electronic contract. You could have it on your tablet. You know, the zip forms contracts. You put them together, and then it fires off to everybody by email. Then they just click here or click there to sign the contract electronically, or they type their name. And then there's an electronic contract. The signature links back to your email. And they're legal in New Jersey now for real estate. You know, Governor Christie, when he was governor, he signed them into law. Some agents adopted them and started using them even before he signed it into law. But those agents, they were putting their clients at risk by accepting digital contracts when technically they were not considered legal. So if anybody ever wanted to sue because of a breach of contract, well, they never had a real contract to begin with if they had an electronic digital contract, and digital contracts were not considered legal yet. So those agents who are quick to adopt the latest technology before the law catches up with it, they're putting their clients at risk. So be careful in the future too, because the law is often lagging with technology. So don't be quick to rush to use the latest technology that's out there if the law has not caught up with it yet. Okay. Oh. So, meeting of the minds. We've had this in earlier chapters, and we've had it in this chapter, and here it is again. Meeting of the minds, the state exam definition, which is the broader definition, which is when the parties are all in agreement and aware of all the terms of the contract. The school exam, they focus on the financial aspect of it. So the definition we need to know there for the school exam is when the parties are in agreement on price, down payment, and the financing method. Kickback is giving anything of value to an unlicensed person, giving a gift, giving a friend money or a gift in exchange for a valuable lead. That is a kickback. Who could you pay? Nobody. Only your brokers can pay people. They could pay their own agents. Another broker when they pay out a referral fee or a rebate to a buyer of a primary residence under certain conditions. We cannot give rebates to sellers legally. That's still illegal in New Jersey. Closing gifts should be limited in value. Keep the value limited down there, approximately $25 or so that it can't be perceived as a kickback. So here are the parts of the sales contract that are essential. Contracts have to be in writing. You got to have competent parties. There has to be an agreement to buy and sell, offer and acceptance. There has to be an adequate description of the property. The consideration, what are the parties giving and receiving from each other in the exchange? The grantor's agreement to convey the property to the buyer, and the place and time of closing should be stipulated, even though that could change. And signatures from all the parties with initials on the bottom of each and every page of the contract, so nobody can swap out one page just by printing it. These are the non-essential elements of a valid contract. We have all these things are referred to in our contracts, and they may not apply to every situation, though. So these are the items that are non-essential because they may not apply to your particular instance in your contract. Encumbrances to which the deed will be made subject to, any deed restrictions. You may not have any deed restrictions, so therefore it's not an essential element to be in that contract. The earnest money deposit, the good faith deposit. We have something in our contracts. People should make a good faith deposit, but it's not required by law. So therefore it's not essential to be in every contract. Mortgage financing, the buyer plans to obtain. What if they're buying cash? Then they don't need to have the mortgage financing listed, so therefore it's not an essential element. You guys are getting the idea. I don't need to keep repeating that part, right? The date of possession by the buyer. Title evidence. What sort of proof of ownership or title evidence does the seller going to have to provide? Prorations and adjustments. These are the last minute financial adjustments from the closing agent. You don't put that in the actual contract. Destruction of the premises. Even though our contracts stipulate what happens in the event the property burns down. Well, the seller put their property on the market. The buyer agreed to purchase it in a certain condition. It's up to the seller to keep the property in that condition. If there's a fire or something happens, well, they need to fix it. Default by either party, what happens? A provision for a final walkthrough on the day of close that doesn't need to be written into the contract. Contingencies. Well, contingencies are happenings in which a contract would be made dependent upon or subject to. We have mortgage contingency clause, inspection contingency clauses. You could also add contingency. This purchase is contingent upon the sale of my current home because I can't afford making the payment on 2 mortgages at one time. Or this purchase is contingent on the completion of my lease, or if the landlord lets me out early so that I could go through with this purchase. Those are happenings in which the contract is dependent upon or subject to. Subject to third-party lender approval if it's a short sale, things of that nature. And signatures of witnesses are not essential elements. We're usually the witness as the agent, but if you don't sign the contract, it's still valid as long as the seller and the buyer signed it, right? Here's some other contingencies often added to contracts. FHA and VA loan addendas. They usually have an addendum that's added to the contract that states that the buyer can get out of the contract if the property does not appraise for the purchase price. That's what the FHA and VA loan addendum is. So if the buyer is using financing from the FHA or the VA, the law requires this addendum be added to contracts. Or subject to engineering reports, or an escape clause, which would protect the seller in the event the buyer makes an offer contingent upon the sale of their current home. It allows them to continue marketing their home for sale. And in the event they get another offer in writing, they could accept that other offer and cancel the one with the current buyer and not be considered in breach of contract. A liquidated damage agreement, short sales, subject to family members' approval, like if family members are helping with the money to buy the house or with the closing costs or down payment amounts. You should always ask that when working with buyers. Where are you getting the money from? Do you got a loan pre-qualification, or do you need relatives or somebody's approval to go through with this purchase? That should be part of your standard questions that you ask. Because if you do have family members that are given the money to purchase the property, but they need to look at it first to give their nod of approval, otherwise they're not giving you the money. That's important to know. Because if you don't write that down as a contingency, and the relatives go through there and say, no, we don't like it, we're not giving the money for it, and then the buyer backs out because of that, well, they're in breach of contract. So if the purchase is subject to the approval of the family members who are helping with the money to purchase, you need to write that in the contract. Actually, the best thing for you to do is get them all through the property before you put the contract together, so you don't have to write it in the contract. Because submitting offers as contingency free as possible makes your offer better than any others that come in. Contingencies are just a way out of the contract, right? So the more contingencies you have in them, the less appealing your offer is. I've had before a situation where I had anybody and their family can help with the money to purchase a property. But I'm going to tell you, by far, Indian families help much, much more. This is much more common with Indian families, where they have family members and relatives and even extended family members that are giving money to help you buy a house. Okay. So, now anybody of any culture, of any background can have family members that help with that. But by far, I've had experienced this with Indian families. Okay. So ask everybody, but especially Indian families. I always ask them, and I've had a situation once where, they said I was writing the contract. I forgot to ask until we were writing the contract. And I'm like, well, where are you getting the money from? I don't have the pre-approval letter here from you. Wait, I did have a pre-approval. And I said, so you're using this this loan to buy, right? And they're like, well, actually, no, we're buying cash. I was like, I thought you were using a loan. They're like, well, we're having relatives. They're giving us the money, but they need to see the house first. And I was like, okay, well, what are their names? And I wrote down 2 names, and then 3 names, and 4 names, and 5 names. I'm like, oh, how many people are involved here? 3 carloads of people of these long Indian names, which were hard enough for me to write down because vowels and consonants go in places where they don't normally go in the English language, So I'm like, oh no. I was like, can we get them all to go through the house? If I set up an appointment for tomorrow, we could get them all through the house. And he's like, yeah, we could do that. And I was like, let's do that. Because writing all these names in there, it makes your offer look weak to the seller. Because you got a list of like 15 people's names here that if any of them say no, that's your way out of the contract. So next day, we set up the appointment, and 3 carloads of people, I got them through the house to show it. They all gave their approval. They were good with it. But there were still 2 family members who were driving down from Canada that had to give their approval. So I had to write 2 family members. But that's a lot better than like 20, right? So I wrote.
So whose name was on the contract? If they're paying in cash, but yeah, all these people have to approve it, and you don't want it to look weak with a bunch of people on there. How do you write the contract?
So I tried to get all those people who are supplying the money to give their approval beforehand, so I didn't have to write them on the contract. So just the
newlywed couple.
Just the newlywed couple's names I put on the contract, and then in down where you could put the notes at the end of the contract, I wrote purchase is subject to these 2 relatives who are driving down from Canada to go through the house, give their approval because they're helping supply the money to buy the house. and they'll be coming down within the next several days. So my job is just to make sure I remove contingencies that are in contracts as swiftly as possible. So once they came down, I took them through to the house right away. They gave their approval. I got on the phone with the attorney and I said, I got them through. They gave their approval. You could remove that contingency. So then they submitted that to the other side's attorney that had been removed as a contingency. And we went out to McDonald's to eat something. All right. Now it could be subject to family members' approvals or subject to zoning or building permit approvals. This is really common with commercial real estate, actually. Builders and developers, they often submit offers to buy land to do like subdivisions and such. And it's subject to them getting financing, subject to them getting zoning and building and environmental approvals and all this stuff. So there's like all kinds of contingencies that need to be met before they'll go through with the purchase. And these offers get accepted all the time.
Could that not be for residential as well? Like if someone's selling a piece of land and they're saying, well, it's subject to
if it's land, for a house, you could say subject to us getting all the permits that are required and permission required in order to build this house at this location and get tied into city services for sewer and water and electric, etc. Yes.
But then that's also on the buyer, correct, to do all that?
Yeah, they gotta get all that taken care of and see if they get the permits for all that. And if they can, then they go through with the purchase of the contract. But the contract's not legally binding until they get through all. Well, contract's legally binding, but they don't. They could still get out of the contract if they can't get any of those approvals.
Okay.
But this way they won't be held in breach.
Yep.
So adding contingencies sometimes is necessary just to protect our client's interest. But be careful adding too many because it can make your offer seem weaker. All right, so here on page 219, let's type subject to next to contingencies. And that common one, the FHA and VA loan, we need to know about this one. You will get exam questions on this. You need to know, what is the purpose of the special contingency clause that must be added to sales contracts when the buyer is getting a loan through the FHA or VA? The purpose of that special contingency clause is if the house does not appraise for the purchase price, the buyer can get out of the contract without penalty. So how do they word that here? They say the FHA and VA's special clauses must be included in the sales contract that provides the contract may be voided if the property appraises below the sales price. Look, they got a bunch of other ones listed here, which I'm not having you highlight, but here, provisions could be added stipulating the seller furnished satisfactory reports on such matters as termite or insect infestation, or maybe inspecting a pool because it's winter and the pool's closed up. Maybe they need to get it inspected to see that that pool is not cracked. We need to get an expert pool inspector in there because most home inspectors don't know anything about pools. Quality of a private water supply, condition of plumbing and heating equipment or septic tanks. In some transfers, a certificate of occupancy must be obtained from a municipality. The contract should make it clear whose responsibility that is. It's usually the seller. The purchaser may add a stipulation that allows a walkthrough inspection of the property shortly before settlement. By the way, those municipal CO inspections are required, and any work must be done by the seller in order for them to get the CO there. It's actually required. I know in Monmouth County, they actually require that the seller obtain those inspections of the heating system and the water heater as well. And then they have to certify that they're in good condition as well. So they go a little bit beyond the normal CO in Monmouth County, which is actually pretty good for buyers. See, among other provisions in the subject to section of the contract are the purchaser needs when the purchaser needs to secure a specific loan, or the purchaser's right to a satisfactory report on the property by a licensed home inspector, or approval of a contract by family members who may be helping with the money to buy, again, within a short period of time, or the purchaser needs to sell their present home before they can continue with this purchase. The buyer cannot be required to complete the purchase if any such contingency is not satisfied. So here we go. We got the escape clause, which is also known as a kick-out or knockout clause. I wrote here on the side, escape, kick-out, or knockout clause protects the seller. So escape clauses are also allows the seller to look for a more favorable offer, with the original purchaser retaining the right, if challenged, either to firm up the first sales contract, waiving the contingency, or to void the contract. So in English, in plain English, dumb it down a little bit. If I make an offer to buy your house, but I got to sell my house first, I can make an offer contingent on the sale of my home. And you could say, okay, we'll accept that, but only if you allow us to continue marketing the property, so that in the event that we find another buyer that makes an offer that's acceptable, we'll come back to you and say, you got to remove that as a contingency. And if you're not ready to, then we could cancel the contract with you so we could accept the other offer and move forward. You good with that? That's called an escape clause. Okay. So if the seller is going to accept your offer contingent on the sale of your current home, well, we'll only accept that if you allow us to continue marketing the property. And if we find another buyer that makes an offer, we could cancel. We could come back to you and ask you to remove that as a contingency. And if you're not ready to, well, we can't be held here waiting for you to sell your home. So we could cancel the contract with you and not be in breach of contract, so we could accept the other offer. That's what an escape clause is and how it protects the seller. Okay. But that buyer has the first right of refusal. So they have to go back to the buyer first and say, are you ready to remove that as a contingency? No? Well, then we're moving on to the next offer. Everybody good here? So here's a bunch of other contingencies. We got that appraisal contingency for that special contingency clause for FHA and VA loans that say that if the house is not appraised, the property does not appraise for the purchase price, the buyer can get out of the contract without penalty. We have a home inspection contingency. Now, remember, it has to be inspected by a licensed home inspector, not by your cousin Vincenzo that knows some stuff about construction. Oh, you know what I'm saying? That's not a way. You can't use any report by somebody who's not a licensed home inspector to argue that we need to get these things replaced and fixed. Only a proper report from a New Jersey licensed home inspector will be considered. Okay. Even if your cousin Vincenzo has been working in construction for a long time and knows stuff. Contingent upon getting a mortgage loan, approval by family members, purchase subject to the sale of the buyer's current home or lease ending. That escape or kick out or knockout clause, which I have an explanation here what that is there again. Expiration of buyer's lease where they're living right now. A use permit for the zoning. A building permit for construction or subject to third parties' approvals. You guys want to snap a picture of this slide? It goes over everything on the last one, including the stuff that I was telling you about. I got it all written here. So if you wanted to have that, you got it right there. Everybody good?
Yes, sir.
Okay. Liquidated damage agreement. We already have this highlighted. If not, on page 219, let's highlight it. I know we already went over it, but let's go to page 219 now, and let's highlight this under contingencies. It's in that section, the last paragraph. Liquidated damages. Let's highlight that first sentence. All right. New Jersey has a plain language requirement that says that you got to use words common in the everyday English language in our contracts that don't have separate legalese meanings to them. However, that only applies to properties valued under $50,000. Ain't a whole lot of them anymore. So that's why it's like a little blurb in the book and no longer a big paragraph. It used to be a half a page that covered that. And we got the right of rescissions here. Let's highlight these right of rescissions or take a screenshot of this if you have not already taken this screenshot in a previous chapter when you. So let's take a look at it. All right, I forgot to continue the recording here of the remainder of this chapter, so the class has already been dismissed. I'm just going to continue on recapping from where we left off so that you have it here in the recording, okay? So the right of rescission was the last thing where we left off in, I believe, so I'm going to continue off from this point. Rescission is the right to cancel a contract within a given period of time. And these are the rescission periods for sales contracts or purchase contracts. And down below is the rescission periods for the mortgage lending financing contracts. So there's a 7-day right of rescission for out-of-state properties marketed to New Jersey residents. And that usually deals with like timeshares and any subdivided land out of state. There's a 7-day right of, and that's only for new construction. And there's a 7-day right of rescission, once again, only for new construction. For large in-state subdivisions, when there's 100 lots or more, or if it's a smaller subdivision, not less than 10 units, if there's common area elements involved, like with condominiums and co-ops. There's a 5-day right of rescission for new construction for the discovery of off-site conditions, things that are not on the property. It could be for one single new home for the discovery of off-site conditions. You have 5-day right of rescission for that. And there's a 3-day right of rescission for new construction and existing resale, the existing resale of existing properties. That's the attorney review period, the 3 days. Now, for the lending contracts, the mortgage contracts, the rescission period is 3 days for refinancing property you already own. And refinancing is basically getting a new loan that pays off the existing one. So you have 3 days to back out of that financing for the property you already own. There is no right of rescission for purchase money mortgages. These are loans used to buy real estate. If you were to read it backwards, that's mortgage money to purchase. All right. So here we have that where we could highlight this information and take these notes. I'll just leave it on screen for a couple of seconds. You could pause it if you need more time to get these highlights because you're only watching this recording at this point. I'm not talking to an actual class right now. Okay. Option agreements need to be prepared by attorneys in New Jersey. Any contract that gives somebody an option, like a lease with an option to buy, we cannot prepare option agreements. They can only be prepared by attorneys. All right. Take these highlights down, and I'm going to go to my slide right after this, which gives a better explanation of what a land contract is. also referred to as installment sales contracts. All right, so land contract, do not confuse it with a ground lease, where a ground lease we're going to learn about in the next chapter, chapter 12, is when somebody leases the ground. It's a long-term lease of a property where they erect a building on it. Okay, so those are going to be long-term leases as well, but that's a ground lease. It should not be confused. Don't confuse that with a land contract. A land contract is a type of seller financing. Your typical seller financing works like this. Just like when you go to the bank and get a loan, you get the loan from the bank, pay the seller gives you the deed immediately, and you make monthly payments over the years to pay off the loan. In a seller financing, instead of getting that loan from the bank, you're getting it from the seller. So they're not actually transferring any money to you. Instead, the seller gives you the deed immediately, and you're making your monthly mortgage payments to the seller over the period of years until it's paid off. But they immediately give you the deed. In a land contract, it's a type of seller financing where the seller does not immediately give you the deed. It's kind of like a rent to own. That's why they refer to it as an installment sales contract. So a land contract, let me read here, is a type of seller financing, also known as an installment sales contract, where the buyer makes payments in installments and then they wait for the deed. It's like a lease to own. So until the buyer pays off the full amount, they do not get the ownership. However, they do have a financial interest in the property through the payments they've been making, building up equity towards that ownership. And we call that equitable title, because equity is built in value through your payments. It's a difference. Equity is the difference between the value of a property and what you owe on it. So equitable title is the word that means ownership. You have equity built up towards the ownership of the real estate. So even though you don't own it yet, you do have a financial interest towards that ownership. So if the buyer ever fails to continue making payments, the seller doesn't have to go through the long, drawn out, expensive process through the court system called foreclosure to regain the ownership of the property that's pledged as collateral for the loan, because you don't own the property. They never signed over the deed to you. So the seller doesn't have to go through the hassle of foreclosure because the buyer doesn't own the property. But it's harder to get them out than a simple renter. So you're more than a renter, less than an owner. All right. Now, equity, I got a definition down here for you. It's the difference between the market value of the property and what's owed on it. It's that built-in value. And you could build equity in three different ways, either by, here's the market value of a property. You buy a property at market value, and through your periodic payments, paying down the loan, you build equity, the difference between what you owe and what the value of the property is. That's one way to build equity. Another is you could do improvements on the property, increasing its value, building equity. Or just through inflation, through the market values going up and down on their own. When the values go up, you're building equity. So that's a land contract, also known as an installment sales contract. It's a type of seller financing. All right, now these are just things that you need to prepare and have ready for you when preparing a contract. So I'll just leave this window open for a second so you could take a look at it. You could pause it if you need to know any of these things instead of me repeating all this stuff again. I'll just leave this on screen for a moment. And then I'll go to the next slide. Here's some additional information. And I'll move to the next slide. Here are some common clauses that we add in as contingencies into sales contracts. I'll pause it. And that's the end of chapter 11. We also went over the key terms to review. So I'm going to do these alone since the class is already dismissed. So I'll go through these and give you the answers as we read them, but I'll pause in between. So a contract that's been fulfilled, or one that has been signed, depending on the contract. That's an executed contract. 12 is A. A buyer's deposit with the purchase contract. That's earnest money. 9 is B. A contract with a promise by each party. That's a bilateral contract. 2 is C. A contract set down in so many words. Well, you express yourself in words, so it's an express contract. 14 is D. A transfer of interest in a contract to a third party. That's assignment. 1 is E. Those legally qualified to enter into contracts. We call them competent parties. 4 is F. A protection for a seller when a buyer has another house to sell. That's called an escape clause, also known as a kick-out or knockout clause. 11 is G. Something of value given in exchange. It's what the parties give or receive from each other. It's consideration. 5 is H. Violation of a contract. That's known as breach of contract. 3 is I. Interest acquired by a buyer with a land contract. Equitable title. 10 is J. Contract that has not yet been performed. That's an executory contract. 13 is K. An offer returned to offeror with changes by offeree. That's a counteroffer. 8 is L. A contract not put into words but shown by actions. That's an implied contract. 15 is M. Certain happening in which a contract is dependent upon. We call that a contingency. 6 is N. An agreement between two parties to perform some legal act. 7 is O, contract. And an agreement under which the buyer pays in installments and they wait for the deed. That's a land contract. 16 is P, also known as an installment sales contract. All right, let's do key terms 2 now. Page 223. A return to the status quo. Status quo is returning to the way you started. That's rescission. When you rescind a contract, you take it back, you cancel the contract, you end up the way you started with no contract. So that's a return to the status quo. 6 is A. Another name for an option contract. It's a unilateral contract. 11 is B. I'm sorry, 12 is B, unilateral contract. A law requiring certain contracts be in writing. That's the statute of frauds. 8 is C. A contract that's binding, but one party may disaffirm it. That's a voidable contract. 15 is D. A sum agreed on to serve as damages in the case of future default. That's liquidated damages. 1 is E. The process of reaching a meeting of the minds. This is also known as offer and acceptance. 3 is F. A substitution of a new contract for an existing one. That's novation. 2 is G. A contract that meets all legal requirements. If it meets all the legal requirements, it's valid. 13 is H. Time within which one is allowed to assert their legal rights. That's a statute of limitations. 9 is I. A court action usually asking that the seller be forced to sell as agreed in the contract. What do we call that court action? Forcing the seller. Specific performance. 7 is J. A convention that a written contract overrides spoken promises. So basically, when one person has a contract in writing and another one's got a verbal contract, the court will kick out the verbal contract in favor of the one in writing because they have evidence. It's the parole evidence rule. 5 is K. A contract that does not meet all the legal requirements. Well, if it doesn't have all the legal requirements, that contract's void. 14 is L. Seemingly valid contract, but neither party can sue to force performance. That's an unenforceable contract. 11 is M. A contract binding one party, the other party's free to act or not. They're describing what? An option. 4 is N. And contract clause requiring punctual performance. And anyone who has not performed on time is in breach of contracts. What do we call that? Time is of the essence. 10 is O. And that concludes Key Terms 2, and Chapter 11 has been concluded.